Hello, everyone, and thank you for joining us. My name is Amanda Kramer, and I am the Alumni Engagement Program Manager at the University of Colorado Boulder's Lead School of Business. These are certainly trying times, and here at CU Boulder, we have gathered our world-renowned faculty and alumni to provide frank and timely insights for life during and after the COVID-19 pandemic. Today is the final webinar in this final spring COVID-19 related webinar series. Stay tuned for additional information about our forthcoming July webinar series. To view upcoming webinars, please visit our website at colorado.edu/business/alumni. Click the drop-down arrow and click Attend Online Webinars. For today's webinar, we're excited to have CU Boulder Associate Professor of Law, Craig Konnoth, here presenting Legal Ramifications of the Nation's Response to the Pandemic. A few housekeeping items before we begin. First, if you have any questions now or during the presentation that you would like to ask Craig, please send a question through the Q&A interface. We will monitor questions as they are submitted, and Craig will respond to them at the end of the presentation. As a reminder, for optimum audio quality, we do have everyone on mute except for myself and our speaker. If you experience any technical difficulties during the webinar, please notify us through the chat interface, and one of our support specialists will touch base. Lastly, a link to access the webinar recording will be sent to all registrants tomorrow, along with a survey link and supplemental resources from today's presentation. Now, I am so excited to introduce today's speaker. Professor Konnoth writes in health and civil rights, as well as on health data regulation. His publications have appeared or will appear in the Yale Law Journal, the Stanford Law Review, the Hastings Law Journal, and the Penn Law Review. At the University of Colorado, Professor Konnoth teaches health law and runs the Health Law Certificate Program. He also teaches sexuality in the law and property. Craig is formerly a Deputy Solicitor General with the California Department of Justice, where his docket primarily involved cases before the United States Supreme Court and also before the California Supreme Court and the Ninth Circuit Court of Appeals. Cases involved the contraceptive mandate and the Affordable Care Act, sexual orientation change efforts, Facebook privacy policies, and cell phone searches. Craig holds a JD from Yale and a Master's of Philosophy from the University of Cambridge. Welcome, Craig, and thank you so much for being here. I'm going to hand the webinar controls over to you now.
Amanda, thank you so much for having me, and I appreciate all of you for being here today. It's, of course, very difficult times, and there's so much happening. And I do appreciate your time. As Amanda said, I teach health law here at the law school, and I specialize in health data regulation as well as health and civil rights issues. I should say that by no means makes me an expert on all aspects of the legal ramifications of COVID-19. And so there might be some issues which are a little bit beyond my expertise. I was talking to Amanda earlier, let's say, about the election law implications. But that said, I will enjoy sharing with you what I do know. Let's see, there we go. So COVID-19 presents a range of legal issues. On the screen before you, you have just some of those issues. Now, as I said, I am by no means an expert on all of them. And indeed, the list I've put up there, I've drawn from a proposed syllabus I recently sent to my dean for a course on COVID-19 and the law. And in the proposal, I actually said to my dean, look, some of these issues I know a lot about, some of them I know very little about, and I will have guest speakers come in for those issues. But as you can see, COVID-19 presents a dizzying range of issues, and I'm going to hit on some of them as I just, as I go through the slide, but then some of them I'm going to go through in a little more detail. So the first issue I'll talk very quickly about is the issue of pandemic preparedness. And that's really a set of policy decisions in terms of deciding how the federal government's going to coordinate with states, how it's going to coordinate with private industry, how states are going to prepare themselves for pandemics. This often involves creating stockpiles, having contact tracing, surveillance systems ready in the case of pandemics, etc. In the federal government also has a very powerful tool at its disposal called the Defense Production Act. The Defense Production Act essentially allows the president to order particular manufacturers to prioritize certain kinds of resources in cases of emergency. Now, emergency here is defined very broadly. The Pentagon used the Defensive Production Act hundreds, if not thousands of times just last year. But unfortunately, with respect to the coronavirus epidemic, there has been great reluctance in the federal government to invoke the Defense Production Act. But usually that would have been invoked to produce tests, to produce ventilators, and the like. So I think that some of the legal ramifications would be thinking about what the federal government could have done better here, what the CDC could have done better in terms of coordinating with states to prepare them to maybe start shutdowns a little earlier, because there's a lot of research that shows that that would have saved numerous lives. But in this case, you know, we did not coordinate as fast. And so one ramification is thinking about how to improve this for future outbreaks of COVID-19, which I expect we will see in the next year or two. The next issue involves surveillance. And of course, one of the issues that come up the most in cases of public health emergencies is, how do we identify who has a specific condition and who doesn't? How do we track someone who may come into the country or into the state who has symptoms? How do we ensure that we can identify those that that individual has interacted with in the past, and try and ensure that they too are protected and are protected from others. So in this context, we've had lots of countries come out with numerous kinds of technology. So in South Korea, for example, we've had facial recognition technology being deployed to identify individuals and the like. There's also, you know, old-fashioned contact tracing, where you identify who tested positive, and then you ask them for their contacts, whom they've been in touch with, whom they've come into contact with in the last, during the transmissible period, and then you try and get in touch with those people. So now, that's an old-fashioned method. It's very time-intensive, very labor-intensive, which is why numerous municipalities are trying to hire contact tracers to do that job. Now, in the United States, we do have technology. We don't quite have facial recognition technology, and I think that that technology would be problematic in terms of privacy for a range of reasons. What Google and Apple have proposed, that they're coming together in a partnership to create technology that would allow the tracking of cell phones. The idea would be that if your cell phone comes within 6 feet of someone else's cell phone, then and that person tests positive, they will collect the data from local public health authorities. Then you will be notified of the fact that you may have been exposed. Part of the problem here lies in the fact that the COVID-19 tests are somewhat unreliable. Some of you in the audience may have tested positive only to test negative the next round of tests you did. They're also, the location testing services are also hard to ensure reliability. So for example, you know, I live in a condo in Denver. I'm probably, you know, if my neighbor is sitting in his living room, I'm probably 6 feet away from my neighbor right now. And if my neighbor tests positive, then my phone will give me a notification saying someone you came in contact with tested positive. And so there's a lot of issues with even with that basic level of tracing. Some localities have said, oh, and can you please give us the names of the people who may have been exposed? And I'm happy to say that Google and Apple have declined to do so, though in my opinion, it shouldn't be their decision. But again, I think that we need to maintain some level of privacy. The third topic is one, so I spoke a little bit about that. The third topic is one, liberty restrictions, which I think will be of interest to many of you. So here I first want to talk about our historical approach in this country to what we do in cases of public health emergency. And then I want to talk about a couple of restrictions that have really come to the fore in the last few weeks. In this country, if you look, the first kinds of public health restrictions we really see in the early 1600s, before there was even an understanding that germs existed. Germ theory only really began in the 1900s, and there were many people who opposed the idea that these microorganisms existed. Many doctors said this was complete nonsense, even at that time. But even back in the 1600s, there was some understanding that there was pollution from infected individuals, some kind of, they would call it a miasma. And so they would say, infected individuals, please do not come into our locality. And so we actually see some of the first public health restrictions from the early 1600s that would say things like, no Indians and no people infected are allowed into our locality, because the idea of infection was very much tied to who you were, to the idea of, oh, are you poor? Are you a minority? We are not gonna let you into our locality. And that understanding actually continued into the early 1900s. And in 1900, we see the Supreme Court, a district court strike down a San Francisco ordinance that prevented Chinese individuals from leaving certain areas in San Francisco because they believed that Chinese individuals would spread the disease. But that was really an exception. The fact was that at this time, we didn't have antibiotics at the time of the founding, and in the 150 years after that, there were no antibiotics of any kind. And when a disease like plague, yellow fever would strike a community, it would run roughshod through the community, killing numerous individuals. And so courts would be very open to the idea that localities, municipalities and states, specifically, not the federal government, which at the time had limited powers, but municipalities and states could use their powers to limit the movement of people. And this they were drawing actually from laws in England from the 1600s, some say dating back to the 1400s, that gave the government this kind of power, because really it was a case of life and death. And so these powers included things like the state saying, sorry, if you are infected, or if we suspect you are infected, because the contact tracing and testing mechanisms at that point were not very good, even if we suspect it, then we aren't going to allow you to leave your house. You are imprisoned to your house. It also allowed situations like we saw in this one case in New Orleans, which went up to the Supreme Court. New Orleans said, look, we have an outbreak of yellow fever in New Orleans, and so we are not going to allow healthy ships from other countries to dock on our coast. Now, the Supreme Court historically had said only Congress can dictate what foreign ships can come into the country and what cannot come into the country. But the Supreme Court said when it came to public health, New Orleans did have that kind of power. And so we actually begin to see states use that kind of power as a pretext to exclude immigrants over time. And I'll talk a little bit more about that in a second. So that brings us to the travel restrictions, the worship restrictions, the other kinds of restrictions we see today. And the fact is that even though in the years after these broad powers were given to public health authorities, The Supreme Court has said, yeah, there's a fundamental right to travel. There are free speech restrictions. There are freedom of religion restrictions. The court has recognized all of these restrictions, and more importantly, has said that the states are bound by these restrictions. But the fact remains that the cases I've referred to regarding public health are good law. And so I've spoken to numerous reporters and others about travel restrictions and other kinds of restrictions we've seen during the epidemic. And the fact is, when it comes to travel, it may be doubtful that a state can just say, sorry, no one from another state or another country can come into our state. Though the Supreme Court has upheld those kinds of restrictions, today that might toe the line of what states are permitted to do. But I think it is perfectly constitutional for a state to say, you know, if you're going to come into our state, there's going to be a 14-day quarantine. And numerous states have indeed done that. Hawaii, for example, has done that. And in Hawaii, we've seen days where there has been 0 new outbreaks of coronavirus. Of course, Hawaii has certain advantages on this front, which others of us do not. When it comes to worship restrictions, many of you may have heard about this case that went up to the United States Supreme Court recently. The question was whether California can continue to ban in-person services. And the Supreme Court said, yes, it can, in fact, ban those services. It was concerning to me that the decision was a 5-4 decision, which means 4 justices felt that California could not ban those services. And the dissenters, in an opinion written by Justice Kavanaugh, said, well, it seems strange to us that you are opening up all kinds of businesses, but you aren't allowing church services. To which Chief Justice Roberts replied, if you look at the businesses that are being opened up, they are very different kinds of businesses. They're the kinds of businesses where you will walk past someone. You might engage in 30 seconds of engagement with someone, 5 minutes tops. We're talking about small groups. Church services, you do have large groups. And in fact, the California regulation allowed for in-person church services if certain kinds of restrictions were maintained. At the same time, anything that looked like church services, like lecture halls, convention centers, things like that, California said you could not open. In fact, California treated churches as well or better than it treated similarly situated entities like lecture halls or seminar type buildings. The fact is that the First Amendment only requires you to treat religion the same as you treat other kinds of entities. The Constitution does not want you to favor religion. It doesn't require you. In fact, in my opinion, it shouldn't allow for favorable treatment of religion. But also, I strongly believe that it cannot disfavor religion. And that's what the Supreme Court opinion in that case that recently came down talked about. Then I recently published a piece on some of the public assistance that the government has provided to individuals. So yeah, it's been shutting down people's businesses. It's been shutting down people's livelihood. And I have argued that both as a moral matter, but possibly as a legal matter, not under the old jurisprudence that says the state has all kinds of power to limit people's liberties during a time of crisis. So under that jurisprudence, the state has all kinds of power. But arguably under the newer jurisprudence, the state has some kind of legal responsibility to take care of vulnerable individuals. And so I actually looked through the CARES Act that was passed by Congress that was supposed to assist individuals. And the biggest sets of protections the CARE Act provides, as some of you may know, is that it provides expanded unemployment assistance, which I can talk about in the Q&A. It provides for the stimulus checks that some of you would have heard of, and some of you may not have received, because there is an income cap for stimulus checks, and that income cap basically starts at $75,000, phases out at $99,000 of annual income in your 2018 or 2019 tax returns, depending, and then if you've got children or a spouse, etc., the calculations change. But there are also state protections, and I wrote this op-ed recently saying that I strongly agreed with Governor Polis's decision to issue an eviction moratorium. In fact, the op-ed was written initially as a call to Governor Polis to issue an eviction moratorium, pointing out that Republican governors, this isn't a Democrat-Republican issue, Republican governors had issued eviction moratoriums, but Governor Jared Polis had not. And I wrote the op-ed, Denver Post had accepted it for publication, and just before they published it, Governor Polis did in fact issue the moratorium. Not, I think, because he'd heard that I had written this op-ed, but the timing was what it was. And so I changed the op-ed to say he has done the right thing. Now you might say, under what power can the governor issue this moratorium, issue various kinds of public health measures? And I actually refer you, there's a statutory citation on the slide that you can see, and that's basically Colorado's emergency statute that, that really looks like the emergency and disaster relief statutes of numerous other states. And I'm taking the eviction moratorium as an example, but there are other kinds of powers that the statute gives. And for example, the statute says that the governor has the power to utilize available resources of the state government and of political subdivisions, so of the counties of Denver, et cetera, to cope with a disaster emergency. But I pointed out that Polis could say, look, rental obligations remain. If you live in your particular apartment, then you've got to continue to owe your landlord rent. But the state isn't going to help the landlord to kick you out. And he gets to say that under the power that says that he gets to determine ingress and egress from a disaster area, the movement of persons within the area, and the occupancy of the premises. So the occupancy of premises within the state, he does have the power to determine that. He also has the power to provide for and make use of temporary emergency housing. As a general matter though, if apart from the occupancy and housing issues, the governor wanted to requisition resources from private individuals, he could do so, but he would have to pay private individuals for that privilege. So as you can see, the issues continue. There are issues concerning federalism, municipal law, foreign relations, tribal law. We see situations where Native Americans are trying to control the spread of COVID on their reservations, but the governors of those states have said, no, Native Americans, we aren't going to let you do this. This is unfortunate because the Navajo Nation, percentage-wise, has seen a spread of COVID that has outstripped those of the most the most contagious states in the country, and they don't really have many resources to control the spread, and so that has been a major problem. And then we've had issues with respect to abortion bans. So what's happened in some states is that, and there was a case that came out of Texas and I think Louisiana, where what the states did was they said, like in Colorado, emergency medical services only, elective services you cannot provide. So if someone wants to have an abortion, if someone simply wants to talk have a consultation with the doctor about the service, in some states, in some areas, the issue has been, sorry, you aren't going to get that service. And the litigation has basically been whether this is an unconstitutional burden on abortion, because obviously, once you reach a certain point in your pregnancy, and we're seeing this crisis drag out for quite some time, an abortion is no longer possible, some would argue no longer ethical. So that has been a problem. Issues pertaining to minorities and equality. We've seen a range of violent, unfair behavior towards Asian Americans, from people not ordering from restaurants anymore to Asian Americans being attacked on the streets. And as something I hinted at earlier gives you the sense, this is something we saw over 100 years ago, where Chinese Americans were treated as contagious. And in fact, between about 1900 and 1950, Congress actually said, Chinese immigrants are not allowed into this country, or there's going to be a significant limited amount of Chinese immigrants into this country. And part of the rationale was, oh, Chinese individuals spread diseases. So there's been this history of anti-Chinese, anti-Asian American attitudes. But we're also beginning to see protests by healthcare workers, by others, who are talking about conditions in this country that make African Americans and Hispanic Americans more susceptible to coronavirus. We know that individuals of certain ethnic groups have lower income, live in close quarters with others, have jobs that we call essential, but often mean that they're low-paid jobs without good health insurance. And these individuals are dying at higher rates. We're also seeing an issue that we've seen elsewhere in healthcare. If you're African American and you go and you ask for healthcare, you don't get healthcare. In fact, many doctors to this day believe that that African Americans have thicker skin and don't feel pain as much as individuals of other races. And so we have stories where African American nurses went to their employer and said, look, I think I've been exposed to COVID, I'm experiencing some symptoms. And the employer has said, stay at home. On several occasions has not treated those workers, and those workers have died. So I have an article that's forthcoming talking about the different ways in which we have discriminated against individuals of minority descent in these contexts. There are so many other issues to talk about here that we do not have time for, unfortunately. We're seeing massive infections. So in fact, in federal prisons, there was a statistic that said 70% of all individuals tested positive for coronavirus. That was an incredible number that I had to reread to make sure I read right. And in some localities, we are seeing release of nonviolent offenders, offenders in places like New York that were arrested for marijuana violations, to reduce crowdedness and spread. We're seeing issues regarding vaccine preparation, how the FDA is interacting with various companies to assist with vaccine preparation. Another big issue is triage. How do you figure out, let's say you're in a hospital, you've got 10 ventilators and 14 patients that need them. How do you decide who gets the ventilators? Is it the people who have the best chance of surviving? Well, won't that discriminate against the disabled and the elderly? What do you do? And then questions of healthcare administration. So we've seen many states, including Colorado, license doctors from out of state, license individuals in their fourth year of medical school, develop compacts with other states and say, look, we're going to have an agreement that allows your people to practice in our state and our people to practice in your state. Telehealth provisions. So doctors can provide services over the internet, and Medicare and Medicaid will reimburse for that. So just a range of issues there. We've heard about the coronavirus outbreaks in meat plants. And there I will note that the president has exerted his power and said meat plants should remain open. But how do you deal with food safety and supply chain issues? And then how do we deal with election law issues? Many of you may have heard about the cases that went up to the Wisconsin Supreme Court and then the United States Supreme Court about remote voting and about postponing the election. And ironically, when it came to Wisconsin, the postponing of the primary and their election, the justices on the Wisconsin Supreme Court and the justices on the United States Supreme Court voted remotely to say that that actually the elections in person could proceed as planned. So there are some hard issues here that we're grappling with, but I unfortunately have to stop there. But I look forward to your questions. Amanda, I'm sorry I ran over, but obviously if we can just keep the same amount of time for questions as originally planned.
Absolutely, Craig. Thank you so much for this information. And as a reminder, please submit your questions now via the Q&A interface, and we will ask Craig. We have a lot of questions streaming in already. The first question here is from Marla. She wonders, is requiring citizens to wear a face mask a violation of the First Amendment under the Freedom of Expression Clause?
You know, that's so interesting. So I'll say two things. The first is that, you know, in normal circumstances, the governor couldn't say to you, stay at home. But under these circumstances, there is good reason to believe, in reference to the case law I cited earlier, that the governor can say to you, stay at home. Saying to you, wear a face mask seems to be much less of a restriction than saying to you, stay at home. So I believe that courts will very much uphold the idea that you should get to wear a face mask. Now, that said, what if you are a person there are policy concerns here, right? So what if you are a person who is hard of hearing, or you know, and therefore needs visual cues, right? And engages in lip reading, etc. And we have seen face masks come out that are transparent. And I encourage those of you who come into contact with people with disabilities to wear those kinds of masks so people can see you lip read, etc. And also if you feel that that limits your expression, then those masks do allow you to express yourself with all the expression you feel is required.
Okay, great. Thank you for that. And next we have a question. Is there a possibility that we would be required to receive the vaccine once it is ready?
Absolutely. So there's an interesting case that if you're listening to a lot of this, you will hear legal experts cite to this case, a 1905 case called Jacobson versus Massachusetts, which came down from the United States Supreme Court. And in that case, the state of Massachusetts required every citizen to get a specific vaccine or pay a $5 fine, which is, I think, about $100 in today's money. Don't quote me on that. I'm not an economist. And so basically, you could easily have something similar here, where the state says, you know, you need to get a vaccine or pay a fine, and that's usually the way it's going to be. You'd get some kind of citation if you don't get a vaccine. It's highly unlikely that the state will isolate you, but you know, look, if coronavirus is circling through the communities, then the state may actually say that you need to be isolated. And the important thing to remember, frankly, is, you know, so there's this great case from 1949 in which Robert Jackson, who was a Supreme Court justice at the time, but he was also the prosecutor of the Nuremberg trials just before that, he wrote the following passage. This court has gone far towards accepting the doctrine that civil liberty means that all local attempts to maintain order are impairments of the liberty of the citizen. The choice, he said, is not between order and liberty. It is between liberty with order and anarchy without either. And there is danger that if the court does not temper its doctrine with logic, with a little practical wisdom, it will convert the Constitutional Bill of Rights into a suicide pact. And so you'll see lots of commenters say the Constitution isn't a suicide pact. And it's important to remember that while we have liberties, we need to also not utilize those liberties in a way that would create vast spread sickness and, in some cases, death. And so when we're in a situation where 150 well, not 150 yet, but definitely over 100,000 deaths are what we've seen in the countries in a couple of months. That situation is one, I think, where mandating a vaccine is appropriate. Now, I'll just ask, I'll just build on that question, and the question might be, can the federal government mandate it? And that's a harder question. The federal government can say to states, you've got to mandate a vaccine or we're going to withhold Medicaid funds. But under current jurisprudence, it's hard to say that the federal government can say everyone needs to get a vaccine. On the other hand, states, the Jacobson case was a state case. Can the state say, get a vaccine or we're going to impose financial or other penalties on you? And on the state, and the law suggests that the states can indeed do so.
Okay, great. Thank you for that. Next, we have a question from Florence. She wonders, do you think immunity from liability for COVID is necessary? Seems as though there's a significant proof problem in such a claim. For example, how does the ill person prove the source of the virus?
Yeah, no, absolutely. I think that there's so much we don't know about the virus, and there's so much we don't know about traceability. I cannot, so I was in this interesting conversation the other day with a couple of other law professors, and that was precisely the issue. How do you prove that you contracted the virus from someone at work? Now, that said, imagine you can prove that you were at home, you only are at home, you get your food delivered, you drive to work, you get out at work, you're in your office, then you go home. Right? So if you're someone who's remaining isolated except for going to the office, or you're remaining isolated except for going to a specific other location, then you might be able to prove it, but I completely agree with you. There's a major proof problem that we will see in many cases. Now, do I think liability is necessary? That is a harder question involving issues regarding exposure, regarding the kinds of damages involved, and I'm not qualified to comment on that. But I do fully agree with you that there will be a major, a major problem of proof involved here.
Okay, great, thank you. Our next question comes from Jeff. He wonders, could you explain more about why Governor Polis was able to execute an executive order stating that businesses can refuse service to customers who are not wearing masks?
Oh, absolutely. So the fact is that I actually feel, so the governor could do this as a public health measure. To my mind, it seems a strange order to issue because, businesses say, they put it on big signs, no shirt, no shoes, no service. So here they're simply mandating another accessory, another wardrobe accessory, which is, and also no mask, no service, right? Businesses have the power to refuse service unless you are a protected minority, right? And historically, we have seen minorities being refused services, being killed, being beaten up if they try and access services, being denied employment. Those kinds of minorities, I feel, do get certain protections under the law, and Colorado luckily protects many of those minorities. Those who refuse to wear masks to come in, like those who may not want to wear a shirt to come in, who may not want to behave or speak in an appropriate way, businesses can say to them, sorry, we don't want to serve you, please leave, right? And so the fact is that businesses can do that without an executive order. So in my opinion, the executive order wasn't necessary. The fact that he may have issued the executive order to clarify the rights of businesses under the law, I think maybe that was a good idea. I don't know if businesses were confused, but the fact is that not only does he have the power to issue the order, he's simply issuing an order that says businesses have the rights that the law already gives to them.
Okay, great. Thank you for that. Next, we have a question from Jamie. You had a slide addressing minorities, and she's just wondering, COVID is disproportionately affecting Black and Brown communities. What legal actions can be taken to correct this wrong?
That's a fascinating issue. And unfortunately, I can't think of a large scale approach, right? So we can think about it in certain contexts. I think that's a great question. So imagine in a prison, right, where we know that Black and brown people are imprisoned at disproportional rates, even in contexts where, Caucasian and I'm Asian American people may perform the crime at the same rate, such as, drug possession, but African American and Latino people tend to be imprisoned more, and convicted more and caught more. So you can imagine some kind of prison action where you say, look, this violates our rights under the Eighth Amendment. Which prohibits cruel and unusual punishment. So packing us in like sardines and allowing for the spread of COVID, that is, cruel and unusual. I could imagine that kind of lawsuit, maybe. In terms of, essential workers, many Black and brown people are essential workers. And we can imagine lawsuits against employers that say, look, employers aren't taking appropriate safety measures in this context. Unfortunately, I have some friends who've, come to me for advice, saying, look, we went to our employers, we actually complained about them to the state of Colorado, and the state of Colorado fired us. And our employers, fired us because they suspected and they knew, it was a small shop, that we were the ones that snitched. So you might have those kinds of measures, but the fact is that these are broader structural inequities. And as long as we have systems that say, that have more police in Black and brown schools and that result to the school and prison pipeline, as long as we're seeing this Black Lives Matter movement now, a resurge in force, as long as we see, police go after Black people more, imprison Black people more, make it harder for them to get jobs because, hey, if you've got a felony record, you aren't going to be hired as a lawyer. You may be hired as an essential worker. So as a law professor, as a lawyer, I work from home. I filed a brief in the 10th Circuit from the comfort of my home. But, the police, when they hear my accent, they stopped me before. They hear my accent, they let me go, So some of that has to do with, I think, structural concerns in a democracy, as long as we have school systems that are funded by localities. If we are more segregated in America than at certain times of Jim Crow. And as long as schools are funded by segregated localities, we'll have poor Black schools and rich white schools like we did during Jim Crow. And when we have that kind of system, then, you aren't going to have a situation where you're going to have Black and brown people getting educations that allow them to become lawyers. I'm from India. My family consisted of some very highly educated lawyers and doctors. I became a lawyer, right? I know Black friends, their career officer in their school said, you will never become a lawyer, right? So these are some broader structural inequities. And so now we're actually seeing healthcare workers protesting during these Black Lives Matter protests. And they say this is connected to our COVID work, because the fact is that unless you deal with those structural inequities, you're going to see higher incidences of COVID. And so we believe the best way to prevent COVID is to correct those inequities. Don't give us ventilators, give us equity.
Okay. Thank you for that, Craig. And we're going to move into our final two questions now. Our next question is from Dave. He wonders, can you please speak to the lawsuits by businesses, for example, Tesla in California, that have been blocked from opening?
Yeah, absolutely. So again, as I said, many of the lawsuits, many of the laws and cases being invoked in these in this litigation connects back to litigation from over 100 years ago. So courts might say, look, the powers of the government aren't as strong as they used to be. There's no indication that's the case. I should have added, actually, when we were talking, that some of the courts, including conservative courts, to the extent that some people believe this falls down within a conservative liberal breakdown, conservative courts have said, no, in these situations, civil liberties are tempered by the idea that the government has power to prevent deaths. They've cited that sentence: the Constitution is not a suicide act. And so, Tesla wants to reopen. The governor of California has the power to order state marshals, state troops to go in and say, Tesla, sorry, you cannot reopen because that will cause deaths, right? And so, in my opinion, those lawsuits those kinds of lawsuits are largely meritless.
Okay.
Under current law, I should say, right? I mean, as I said, the courts can change their mind about the law, and then we're in a different world.
Okay, great. Thank you for that. And moving into our final question from John, he said, Professor Konnoth, do you advocate for principle-based or rules-based legislation?
I think the answer is it depends, right? And that's a very lawyerly, you might say, wiggly answer. But the fact is that, you know, if we look at the laws we live under, some of them are principle-based and some of them are rule-based. You know, no one under a certain age can run for president. That's a rule, you know. But, you know, no state can deny equal protection of the law. That is a principle. What does equal protection mean, right? And so that's the way the law works, right? Sometimes we can say, here's a concrete rule. Sometimes we can say, you know, look, we actually need some flexibility in certain situations, right? And it depends on what the purpose of the law is. The Constitution is nearly all principle-based because it's meant to serve us for you know, hundreds and hundreds and hundreds of years, right? As the famous Chief Justice John Marshall said about this, it is a constitution we are interpreting. And what he meant by that in that context was we need to understand there's going to be some flexibility. On the other hand, speed limits, I think a rule is ideal because that then gives clarity to individuals as to what they can and cannot do. So there's always that give and take, and I think that that flexibility is an important part of the law.
Okay, great. Well, thank you so much to everyone for joining us for today's presentation, and a special thank you again to Craig for this great information. As a reminder, all webinar attendees will receive an email tomorrow with a link to the recording of this presentation. To view upcoming webinars as well as previous recordings, please visit our website at colorado.edu/business/alumni. Stay tuned for more information on our forthcoming July series. In the meantime, have a great rest of your day and go Buffs!